Hi, everybody. Thanks for joining us today. We have a case regarding a defect on a residential real estate transaction and how it was discovered before closing, and the buyers tried to get out of the agreement by relying on a clause that was in the agreement regarding detrimental conditions in the property. The sellers refused to honor that clause, saying that it did not apply in the situation in hand, and the court ruled in favor of the sellers. And there was around $200,000 in damages, which the buyers had to pay to the sellers in the form of difference in purchase price for what the sellers would eventually sell the property for, rental costs, and some other stuff. So huge amount here, $200,000. And this, of course, is in addition to the buyers having to fix this issue. So very unfortunate for the buyers. And let's take a look at what happened here. So this was a 1958 Hamilton home. The home inspection condition was waived, and there was this non-standard detrimental condition clause, which we have here up on the slides. And basically, it says, the best of the seller's knowledge and belief, there exists no detrimental physical or psychological condition affecting the property that might negatively affect the value of the property or influence the buyer's decision to proceed with the completion of this agreement of purchase and sale. This warranty shall survive closing of this transaction, but shall only apply to circumstances existing at or before closing. So that's the clause, kind of a non-standard clause. And I do confirm it does say physical or psychological. I'm looking at the case in Canley, so very strange language. I'm not sure what is meant by psychological condition, but anyway, it does talk about a detrimental physical condition. And so the key discussion here, the key argument between the seller and the buyer, in this case sellers and buyers, I mean, is whether this clause applies at the time of closing. And what I mean by that is that if any conditions or detrimental conditions are discovered before closing, whether this clause kicks in. So the buyers argued that yes, this clause, and if any detrimental conditions are found before closing, this clause applies and we can get out of the agreement. The seller said, no, this clause is written that at the time that we signed the agreement of purchase and sale, we, the sellers, didn't know of any detrimental conditions. So it applies at the time the agreement of purchase and sale was signed, and there's no evidence that we knew of any detrimental conditions. Therefore, you cannot rely on this warranty. And the buyer said, well, why does it say it will survive the closing of the transaction and shall only apply to circumstances existing at or before closing? So this little last bit of the clause is why the buyers thought, well, it covers us until closing if there's any detrimental conditions found. And the court found that the sellers are correct. The court did not side with the buyers. The court said that the way this clause was written is that it talks about the sellers having knowledge of a detrimental issue at the time they signed the APS, the agreement of purchase and sale. And that survives closing, and it applies until closing, that whether they knew of something wrong with this property. However, this clause doesn't mean to say that if something is discovered after the APS is signed and before closing, that the buyers can get out. So the wording is not precise. Basically, this clause lacks what's called a bring down obligation, which means that if the sellers or the buyers or whoever has knowledge of a defect up until the day of closing, or a defect is discovered up until the day of closing, then the buyers can get out. So the lack of this bring down language is what caused this clause to fail for the buyers. So basically, it did not cover the time between the APS was signed until closing. If any issues were discovered during that period, it would not allow them to get out. Any new issues that the sellers did not know about. So if the seller did not know about something at the time the APS was signed, and then the seller discovered something after that, the clause doesn't apply. So that is the key takeaway here, this bring down obligation. So That's the lesson in this case, a very, very big lesson, $200,000 lesson, that these clauses have to be carefully drafted to have this bring down language. And I don't have a sample language of what I would suggest, but you can look up bring down language, or sometimes they're called bring down certificates even. And I'm sure you will be able to find the proper language to make these kind of clauses apply until the date of closing. So if the sellers have knowledge or new knowledge after they sign the APS, the buyers can still get out. So I hope you found this video useful and interesting. Thanks for watching, and I'll see you next time.